Welcome once again to Lehto's Law. Here's Steve Lehto.
Kevin sent me a note. Says, Steve, check out the article in The Verge by Sean Hollister. The Federal Trade Commission is investigating PC manufacturers who scare you away from your right to repair. What we're talking about is those stickers that you'll often see inside or holding something shut that if you remove it, it'll say warranty void if removed. And I remember seeing these a lot in computers in the old days and other electronic devices. And so people would stop and go, wait, is this true? And many people believe anything they see if it's printed on a sticker or a sign. And it says warranty void if removed. So if I remove it or break it, I guess I got to either buy another one or bring it back to them to have it repaired, whether or not it's under warranty. And that's the interesting thing. So those stickers often cover screw holes on a gadget to make sure you can't take them apart. And now the Federal Trade Commission is reminding ASRock, Gigabyte, and Zotac that they are, in fact, illegal. The FTC sent letters to those three companies suggesting the FTC's concerns aren't just sticker deep, as Sean Hollister says. Each letter tells the manufacturer to change its warranty and review its customer support practices to make sure they aren't illegally threatening your warranty. You might say, Steve, there's laws about warranties? Yeah, there's a law called the Magnuson Moss Warranty Act, and it's a law that a lot of consumers a lot of consumer protection attorneys like myself use when we sue manufacturers over defective products, including cars, that have warranties that weren't honored. But the same statute, the Magnuson Moss Warranty Act, it's a federal statute, also defines what manufacturers can and cannot do with warranties and what they call their warranties and how the warranties are handled. And so it's all in there. And so this law has been on the books for decades. So there's no excuse now to not know this if you are a manufacturer putting out things with warranties. Staff would be concerned if Gigabyte in practice denied warranty coverage based on the warranty provisions quoted above or any similar provisions, says one of the letters. As of now, each of these companies' warranties does include such a threat. The very first line in ASRock's warranty reads, manufacturer's warranty will be null and void if products are modified, damaged, or otherwise tampered with. For example, the outer case is opened or additional optional parts and components are installed or removed. Now, you go, Steve, are you telling me that if you damage your product, they've got to fix it? No. Keep in mind that the way this sentence is written, it says manufacturers will be warranty will be null and void if products are modified, damaged, or otherwise tampered with. For example, the outer case is opened. So in other words, they're saying that if you simply opened the case and then closed the case and send it in, they can say, we have to work on this now. You opened the case. So Gigabyte's warranty says if the manufacturing sticker inside the product was removed or damaged, it would no longer be covered by the warranty. The way that's written almost sounds like the warranty's on the sticker itself. The particular right to repair law the FTC is invoking here isn't one of the state-by-state ones. It is the federal Magnuson Moss Warranty Act that attempts to keep companies from making bad warranties and misrepresenting them in the first place. So Mag Moss does a whole bunch of stuff. And that's a great summary, by the way, but I'm just pointing out that Mag Moss creates a private cause of action against a manufacturer who gives a warranty and the product is above a certain threshold of dollars, it's usually very low. And you can then sue them, and if you win, for breach of warranty, you can sue them and get your attorney fees and court costs paid. That's huge. But also it says if you put out a warranty, you've got to describe whether it is a full warranty or a limited warranty. And if it's a full warranty, it's got to do these things. If it's a limited warranty, it's got to do these things, and you have to explain them. And so a lot of what the statute is designed to do is to clarify for consumers what the warranty actually does. You'll discover that almost no warranties are full warranties anymore because to meet that standard, it's almost impossible, and manufacturers don't want to do that. So you'll always see this manufacturer's limited warranty does this. And now that I've told you that, if you did not know that previously, the word limited will become ubiquitous in your life and you notice it in front of every single warranty you look at. It's just how it is. The Act prohibits warrantors of consumer products costing more than $5 from conditioning or written warranties on a consumer's use of any article or service, such as repair service, which is identified by brand, trade, or corporate name, unless the warranty states the article or service will be provided to the consumer for free, or the warrantor has been granted a waiver by the commission. So I've had people say, but Steve, if I have a product that is so complicated and difficult to work on that an average person cannot work on it without damaging it, well, you can go make the case to the Federal Trade Commission and say, hey, here's why I want to put that in my warranty. They might agree with you. And if they do, you can put the sticker on there. But if they don't, you're right here. FTC investigators have copied and preserved the online pages in question. We plan to review your company's written warranty and promotional materials after 30 days, the agency told those firms. So it's interesting because in the old days, you had to actually buy a product and read the packaging or the owner's manual to see what it would say. Nowadays, you can go online and just look at it and screen grab it. In 2018, the FTC put Nintendo, Sony, and Microsoft on notice for doing the same thing with their game consoles, as well as Asus, HTC, and Hyundai. Nintendo, Sony, and Hyundai updated their policies less than 2 months later. So iFixit has a blog on how warranty voided for removed stickers may be illegal in other parts of the world, but not in the U.S. Asus has also been recently rethinking its customer support and warranty after a Gamers Nexus investigation, but that one didn't have to do with voided warranties. And so that's another problem you've got to think about. Is we've talked before about how automobiles in America are basically built to two different standards. They're built to the national standard or they're built to the California standard. And California, for the longest time, has had its own standards, and the feds have approved this. And so you often hear about a California car, back in the old days especially. And so if you're a car company and you're building cars and you want to sell them in California, you got to be aware of the fact that there's a different standard for California than there is for the other states. Likewise, if you're making products that are going to have a warranty on them and selling them worldwide, you're going to need to talk to some people about how to do that to make sure that you comply with the warranty standards in each of those countries. And I don't know if any countries out there have identical stuff, in a manner of speaking, to our Magnuson Moss Warranty Act. But let's suppose that you are, in France and making stuff and you plan on selling them to America with some kind of warranty. And if you do that and Americans buy them here, then the Magnuson Moss Warranty Act would cover it. And so I don't know where these companies, AS, Rock, Gigabyte, or Zotac, are located, but if they're selling stuff here, they got to follow our laws. And there you go. And so it's amazing because I remember a law school professor of mine, this is back in 1989 or 90, I remember him talking about how the Uniform Commercial Code, when it first got passed and was accepted and adopted in a variety of states, how many lawyers were like, oh my gosh, this is so cool. They finally put all this stuff in one place. Because what the UCC did was it gathered up all these different concepts that were scattered about the different law books on contracts and sales and secured transactions, Article 9, things like that, and put them in one uniform commercial code where you could find all this stuff. And it simplified a lot of things. But I remember this same professor saying the funny part was that students had come back to him and said, it's hilarious because there are old school judges and old school attorneys who had no idea how comprehensive and universal the UCC was in that it covered all this stuff and simplified it by putting it all in one place, and it all made sense. Suddenly one confusing thicket of the law had been clarified and streamlined. And so likewise, a lot of the concepts that are in the Magnuson Moss Warranty Act were already out there on some level or another. But you'd have to make an argument in each state to be different based on that state's laws and so on to convince somebody that a full warranty that had limitations on it wasn't a full warranty. You get in these arguments of what does a full warranty mean? And the seller would say, oh, full warranty just means this, that, and the other thing. And the buyer goes, I thought it just assumed, I assumed it meant this. And you'd get in these fights. No, Mag Moss now says if it's a full warranty, it must do this. If it doesn't do these things, it ain't a full warranty. And if it's not a full warranty, you have to label it a limited warranty. And so there are some things now where I guess if you weren't thinking and you started a company and you literally took no advice from anybody and you started selling widgets and putting full warranty on them and didn't know it, I guess I'd feel sorry for you on some level. But then again, that's one of the reasons why when you get in a business, you're investing a lot of money, Once in a while, you want to bring in some experts and ask some basic questions, such as, can we put this on our packaging and call this a full warranty if we're going to do things like this? And these aren't full warranties, by the way. These are all limited warranties. But the point is that even with a limited warranty, you can't say, oh, by the way, simply damaging this sticker will void your warranty. They can't do that. They can't do that. And so, again, I understand the counter argument. Someone's going to say, but Steve, we all know what they're getting at. They don't want you opening up the box, poking around in there. Next thing you know, you've damaged it. You put it back together again and send it in to them. And the first clue to them that there might have been something like that would be to see that the sticker's broken. Okay, but now the question is, who did the damage inside? And if the customer did that, then yeah, you might not have to worry about paying a warranty claim. But that's been the law all along. And so that sticker could be placed there just to indicate the box has been opened, but putting a label on it that says warranty void if removed is a step too far. So Kevin, thanks for sending it. That's from The Verge, great article by Sean Hollister. The Federal Trade Commission is investigating PC manufacturers who scare you away from your right to repair with those warranty void if removed stickers. I got to get a shirt that says that, warranty void if removed. Questions or comments, put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law. Do memory foam mattresses wish they could forget?